Hi, I'm attorney Michael Potter, and today we'll be talking about the limited liability limited partnership. Now, while it's true that all 50 states do recognize limited partnerships, the level of protection that's offered by limited partnerships is by no means equal. Some states have a much greater level of protection than others based upon their statutory laws. Now, in the past several years, some states have begun to adopt a more advanced version of the limited partnership, one that provides greater protection. That's known as the limited liability limited partnership, LLLP, also known as the triple LP. It started in the state of Nevada and is gradually being adopted in other states. Whether you are living in the state of Nevada or not, you can still form a Nevada triple LP and put it to good use in your own planning. So what is it that makes the more traditional limited partnership all that different from the more advanced version known as the limited liability limited partnership, or triple LP? Well, really, it boils down to two things. Number one, the more advanced version offers a greater degree of protection, and it limits the creditor to one sole remedy under the Nevada sole remedy law, and that is the charging order. Now, a charging order is a severely restricted remedy, and it's only applied in specific kinds of circumstances, namely when the general partner of the limited partnership decides to make a distribution, which is discretionary. Only then can the charging order be applied, and under very restricted circumstances. Now, in the typical optimum planning situation, the general partner is either going to be you or an entity that you control. And as such, you'll be able to control the general administrative and management decisions, the investment decisions, the type of assets, where they are allocated, and under what conditions can they be liquidated. Now, there are about three different ways to go with respect to who should be the general partner. And I'd like to just briefly touch on each one of these. The first of these is you can personally serve as the general partner in your own name. It's done every day. It's perfectly legal. And that is the way, frankly, that many people set it up so that they personally serve with their own name as the general partner of the limited partnership. The second way to go is to use a corporation as the managing general partner. Now, that can give you not only some privacy and control, but also give you a greater degree of tax planning with respect to benefits of the corporation. Now, there is a third way to go with respect to who should be the general partner, and that is to use a Nevada Privacy Management Trust. Now, in the past, in the traditional limited partnership, it was the limited partners who enjoyed all the asset protection. Under the triple LP, you as the managing general partner will enjoy the same degree of protection as the limited partners do. But who should be the limited partners? Well, there you've got a variety of choices. Now, in the first instance, you could be joining with family members, friends, people in your circle of acquaintances, co-workers, fellow investors. They could come together and be the limited partners, and that would be perfectly all right. Now, in the slide that's coming up, I'd like you to pay attention to the right-hand side. You're going to notice in the next slide that there are two trusts as the limited partners. Now, of the two trusts that are working as limited partners, one of them is the revocable living trust, the one that most people think of when you hear the term, I have a trust. The other partner, the majority limited partner, is the Wealth Preservation Trust, which is covered under a separate series of videos, which I hope you'll watch. That will give you a much greater degree of privacy, tax planning, and asset protection. Now, we spoke a moment ago about using a couple of different kinds of trusts as limited partners, one of them being the Revocable Living Trust and the other being the Wealth Preservation Trust. I'd like you to consider a third possibility, and that would be to use possibly the multi-generation dynasty trust. So that would give you three options that you could use in planning who the limited partners would be. Each of them have their own strengths, and each of them can stand on their own. But by combining the living trust with either the Wealth Preservation Trust or the Dynasty Trust, then by that combination, you've got the greatest combination of strength, privacy, tax planning, estate planning, and asset protection. Now, there are a variety of kinds of assets that can be held inside of your limited liability, limited partnership. And I like to break it down as to the use of those investments. For example, the first category that I would designate would be the direct investments. That would be your mutual funds, your stocks and bonds, and your trading options. They can be held directly by the limited partnership. Next, I'd like the limited partnership to own any corporations because that will give you a mix and some flexibility with respect to tax planning, calendar year income planning, and so forth. That can be a wonderful way to go. Now, for further layering and greater protection, both for flexibility and asset protection, you may want to consider having limited liability companies owned by the limited partnership. That will give you multiple layers for asset protection and give you a high degree of flexibility in terms of income flow, deductions, and the movement of resources that will optimize your asset protection capabilities. Well, as usual, I've given you a lot to think about. I'm sure you probably have some questions. And if you do, please feel free to get in touch with me. I'm attorney Michael Potter, and I look forward to hearing from you.